A lot of people I respect out there just do not understand what happened in my case with Blake Lively. And a lot of people are saying my lawyers missed a lot of stuff. No, they didn't. In fact, I got them here right now to defend themselves and for me to stand by them. Because guess what, folks? We're going to appeal. It's official. We've filed it, and we got so much to tell you guys. Welcome to Popcorn Planet. I am Andy Signore. I'm so happy to be here with my attorneys, Jack Gordon, Dave Mitchell. Fellas, welcome back to the show. I gotta be honest, I know we're all disappointed, but I've been more frustrated by some of the, I gotta say, ignorant or just uneducated takes out there as to what they think happened in our order from the judge. And it's massively frustrating. Now, I made a video, we've talked, and I've shared some of the thoughts, but I wanted to get you both in here, not to defend yourselves in a way, but kind of I feel like I'm forced to explain ourselves as to why so many people out there are missing what's going on. I want to get right to it. I know you guys got a lot to say, but like, here's an example from my reading of the, and these are people I love, Larry, no disrespect. These are lawyers out there in the YouTube space. From the reading of the record, Andy's lawyers missed the deadline to quash the subpoena. That's the only reason Andy has to respond to prove it. His business records by December 17th. It's really a simple issue that could have been avoided very easily with a timely filing by Andy's lawyers. Their failure to act is why Andy is where he is right now. Here's another one from Legal Bites. I have what may be an unpopular opinion. Signore was always going to lose this because his lawyer didn't do what they were supposed to do and ended up waiving any privilege he may have had. Jack, let's start right there with this criticism I'm seeing across the bat, which I've been out there responding and defending. Is that true, Jack? Did we not respond and do what we were supposed to do?
No. Again, we appreciate your continued trust and confidence, but you know, here's what happens. Even as professional athletes, when you get a bad call, right, an umpire or a referee makes a bad call, you can lament about it, and we always go back and we review the film and what perhaps could we have done better. Nothing. In other words, this was picture perfect lawyering. And again, it's a very discouraging opinion, and clearly we're disappointed. But this is not unlike a bad call in a professional athletic competition. And you can bemoan what happened, or you can take action and continue to rally and fight as you're doing. So there are some certain procedural circumstances that I'm very disappointed in the manner in which the court ruled. Again, I'm not disparaging of Her Honor Judge Griffin. I think she's an excellent judge, but there are some questionable thought processes being expressed in her opinion as it relates to some procedural circumstances. And then most importantly, from a substantive perspective, to just make a determination as a summary matter that someone who is not publishing a magazine or otherwise considered to be part of mainstream conventional media can never be afforded the same rights as someone, again, who does enjoy those benefits. The First Amendment applies, remember, to the lonely pamphleteer as well as it does the large socioeconomically audible voices in society. But again, with all due respect to the viewing audience, no, you guys just don't possess the legal sophistication to understand what happened here. This was not a function.
Dave, I'm going to go to you, but I'm showing it on screen. Like, here's our motion to quash. If you go and check out the motion to quash, literally, which none of these people did, you would see right here, we're calling reporters privilege day one, right, Dave? And that's really what we had to do, correct? Can you elaborate?
Right, that's right. And additionally, we had an agreement. The record doesn't show this because it's not part of the record. We had an agreement with Blake's lawyers to file it when we did file it, so it wasn't untimely filed. That argument was never even made by Blake's lawyers. The judge raised that sua sponte, which is another, outcome determinative suggestion here that this ruling wasn't based on anything that was actually in the record, which is very disappointing, obviously.
Yeah, but again, because if there was some procedural deficiency as it relates to timeliness, then Blake Lively's lawyers would have objected, could have objected, but clearly didn't, and otherwise confirmed that everything was done timely. The other issue that's procedural in nature, and Dave can probably speak more intuitively about it, but one of the criticisms from some of these, I don't know how to characterize the people who are critical of what you're doing and what you've done, Ange, but these people who are critical just don't possess proper legal sophistication. Contrary to this indication that a privilege log is required, when you file a motion to quash and make a blanket assertion that privilege applies, there is no requirement to file a log. That's the whole purpose that you file the motion to quash, because sometimes even in enumerating what it is you're in possession of, you might be subconsciously or inadvertently providing certain disclosures that you as a journalist shouldn't have to disclose.
Right. There's black letter law supporting that. It never came up. We never made the argument because the argument never came up during any of the case management hearings that we had, which is why it really came as a shocker that it was part of the order. It was never argued by any side, either side.
There were a lot of promises in those hearings. And again, I'm trying to be respectful for the judge as well. And she also acknowledged she was unfamiliar with a lot of this. So I was actually hopeful because I'm like, okay, great. She's going to really try to learn and hear it all out. But we didn't even get our final hearing or a go by, there was a lot of stuff, guys. You don't realize in those hearings, as transcripts eventually come out, you'll see we were left pretty much in the crapper with her seemingly having an opinion. I feel, that she had early on, right at the beginning of the case. I mean, is that fair of me to assume?
When you say early on, I don't know about early on, but Dave uses a particular term, outcome determinative. And it's clear to me that this was an outcome determinative conclusion, meaning she knew where she wanted to go. She wanted to deny Popcorn Planet the same privileges of First Amendment that all journalists otherwise enjoy. So the question was, how was she going to get there? So there's a principle in law called the Tipsy Coachman principle or doctrine. And we see it specifically in appellate law. When a judge reaches a conclusion, but for the wrong reasons, the appellate court will still uphold that decision, saying, well, it's like a taxi driver who's drunk. He may go the wrong way. He may go the opposite direction up a one-way street, but he still gets you to where you should have been delivered to. And based upon the manner in which this order was drafted, it's clear that the court was trying to protect itself in its conclusions, because it's based on an alternative set of algorithms, if you will. The court makes a determination that the journalist privilege doesn't apply. But in that same order, however, if the court's wrong and the journalist privilege does apply, then there are certain bases upon which Blake Lively can overcome that. But then there's no basis from an evidentiary or substantive perspective as to how Blake would otherwise have been able to overcome that privilege. There's a compelling interest that you have and that we have as you have as journalists, and we have as an obligation to protect journalists, to make sure information is not inadvertently disclosed and to make sure there are no hardships provided to third parties. You are not a party to this action. You don't have a dog in this fight. This is between the Wayfarer defendants, Baldoni, and the Blake Lively camp. Yet you are otherwise caught in the middle, in the crossfire, and it's costing you a tremendous amount of money, time, energy, effort, and resources. In this case, we provided a substantial amount of affidavits, evidence in this case. There was no evidence ever provided by Blake Lively in no uncertain terms. We demonstrated hardship. We provided invoices showing the amount of money you're being required to spend. You even, and it was beautiful because at a hearing, it's not something that we normally see. But again, someone of your socioeconomic sophistication, given the intelligence and your ability to articulate matters, we said, Judge, go ahead and ask Andy yourself. And she asked you questions and you explained it in a very straightforward fashion and specifically advised the court that you would make your your own ledgers, your own financial records.
Yeah, I did that through an affidavit. I didn't get to talk in court, but I did it through an affidavit. Absolutely. And none of them took it. Like, I thought that was the whole heart of the case. What she says is, I mean, I want to show this part, the heart of the matter, which she gets so wrong because she never understood the actual case. But to prove what you were saying earlier, there's this whole thing of just where she even says, even if required, even if this got this, even if, like, she's constantly one-upping, like, well, okay, even if I'm wrong, well, there's this then. And even if that's wrong, then there's this then. But in a way where none of them are focused, which for my limited experience of the law is not how it's supposed to be. And I want to spotlight, I have some on screen, I know you guys can't see it, but there's this whole thing about, arguing about the scope and whether the materials are more convenient from another source. Rule 45 requires a party to exhaust all other source information, even if required. Even if that's required, which it is. Lively has attempted unsuccessfully to obtain the same communications from the defendant in the underlying case.
There was no showing.
Which
there was no
we know how.
When did Blake come testify? Everything was sealed.
It's not only did we introduce evidence, and were we the only party that introduced evidence, they didn't introduce anything, and in fact hid behind the privilege of the seals that were filed up in New York to shield themselves from having to discuss any evidentiary matters on their side. So how does the judge know that Lively attempted unsuccessfully to request these from third parties? We don't know that, because every time we brought it up at a hearing, Lively's attorney said, Judge, that's sealed. They couldn't possibly know that.
You asked for these, just so we're clear, as I'm looking at the docket, you asked for those documents. It's in there, right? There was a point where we were demanding some of those exhibits. What's that called, Dave?
There's a request for judicial notice where we actually submitted to the court that this is the status of the discovery matters up in the New York case, and Blvd's counsel here said, well, that's not 100% accurate, Judge, but I can't tell you anymore because it's all under seal.
But what we were able to do was
that's what it's called.
We were able to demonstrate it almost by inferentially, by purposes of, by reason of deduction, because they did file specific motions to compel discovery of certain items, suggesting that the Baldoni or the Wayfarer defendants didn't provide it. But Popcorn Planet was not among those things that they specifically indicated were not properly provided. So we were able to demonstrate that inferentially. We're just disappointed from a legal perspective as follows, guys. You know, for any decision that needs to be made, especially at a federal level, it has to be supported by both common law, meaning case law precedent, history, other appellate courts, or other courts of similar jurisdiction, and it has to be supported by legal authority or statutes. And in this particular circumstance, there is no law that supports this conclusion. So it's interesting because the manner in which the order was drafted, the court relies upon certain website, certain online dictionaries, doesn't rely upon any case law. The one case that is pretty much directly on point involves BuzzFeed. It's not authoritative because it's at the same level. It's a Southern District. There are 3 district federal courts in Florida. We are in the Middle District. The Southern District basically decided the same exact circumstance. Was BuzzFeed an online media source eligible for the same First Amendment protections as all of the conventional news agencies? And the court said yes. In our circumstances, Her Honor Judge Griffin said, well, I don't really find that case very persuasive. So I don't think I'm going to consider it. But then she quotes portions from that case to support other parts of her order. The other issue is the one case that the court does reference does not involve the journalist privilege. It's the McDermott case, which involves the clergy privilege, and it's a criminal case. And the clergy privilege is not provided for anywhere in federal law. It's only based upon the Florida statute. But this court utilized that reasoning to support the decision that we couldn't get into some of the protections otherwise set forth by the 11th Circuit Federal Court of Appeal.
Right.
Well, and just to add one more thing, I want to go to you, Dave. Like another part I want to address is now they've delayed this trial 2 months, which and acknowledging that they have so much evidence they still haven't been able to get through. And at no point did any issue of Popcorn Planet's communication come up at any play in any of these things. So, Dave, I mean, this only helps and proves how odd the judge's ruling was in our case about how urgent and everything else that this ruling was, no?
Yeah, I agree with that. I mean, it's just more, it just adds more to the pyramid of information that we already have built up by way of inference that they weren't really ever after anything that Popcorn Planet had, or they believe Popcorn Planet had. I say the golden ticket there is their disclosures that they filed with the court. You're required to file what's called initial disclosures or Rule 26 disclosures that identify all sources of information that you believe exist. Popcorn Planet wasn't even mentioned in that. You know, they didn't mention it then. They didn't mention it in the summary judgment filings. They didn't mention it as part of a basis for continuing the trial or any of that. So, you know, it seems pretty obvious that they never.
Guys, and with all due respect, we're talking about this from an academic or legal scholastic perspective. This isn't about them trying to get information. This is all about trying to squelch or otherwise silence Popcorn Planet. It's as simple as that, because you spoke critically in a critical manner, and now they're attempting to punish you by virtue of, again, the resources they have.
I mean, you guys have said it feels like they're coming for me specifically, like they have something out for me. It's
absolutely
really weird, personal, no?
And I know you mentioned some of the folks have talked to you about, other subpoenas that were quashed. No, there were no other subpoenas that were quashed. What happens was other subpoenas were withdrawn. These subpoenas against you were not withdrawn. The only ones we were successfully able to convince the other side that they should withdraw was the Google subpoena. But this is the only time that a court has, in this particular circumstance, has ruled on whether or not to quash. And again, in this circumstance, the court ruled in the negative. But I got to tell you guys, again, not unlike if you get a bad call on the football field, you can do a replay, but at the end of the day, if the play on the field stands, it stands, and you have to continue your fight. You have to continue your struggle towards victory.
Well, the play might not stand, right? Because we filed a notice of appeal, and now we've got multiple avenues. Let's talk about that.
That's why we continue the fight. Well, first, let me say this before we go into that, because what I find most encouraging is the manner in which the large journalist organizations and the well-respected legal First Amendment entities have reached out proactively to us as lawyers, to you, Andy, as a journalist, and have pledged their support. And we can talk a little more about amicus curiae in a bit. But the numbers of organizations, from the Freedom of Press Foundation to the College of American Reporters to the University of Virginia Law School, Duke Law School, University of Georgia Law School, First Amendment clinics. It's just
so many
amazing
acronyms. I'm forgetting which ones are which. But yes, we've been inundated with a lot of support, which I'm grateful for.
The amount of legal scholars who agree with our position and are otherwise critical of this ruling is just, it's profoundly inspiring to me.
Yeah, and let me say this, even really good judges make wrong rulings sometimes. I mean, if trial court level judges always made the right ruling, we wouldn't need appeal courts. We have appellate courts. If appellate court panels always made the right ruling, we wouldn't need the Supreme Court. The fact of the matter is, in this case, at this level, it's one judge making a decision, and one person can be wrong sometimes. And in this case, we believe she was wrong. As you go up the appellate scale, the panels get bigger. You have more people having to decide these things. And that's why when you get to the Supreme Court level or even en banc at the circuit court level, the decisions tend to be a little more palatable. Right.
And this is a circumstance, and again, we don't want to be disparaging the judge because I'm familiar with the judge. I think she's made some great rulings in other cases. Yep. I have a tremendous amount of respect for her. But again, you talk about Tom Brady being perhaps the GOAT, the greatest of all time from a quarterback perspective. Once in a while, he threw to the wrong guy. He threw into triple coverage, right?
Yeah, he lost the Eagles in the Super Bowl. It was beautiful.
That he shouldn't have thrown.
Back into the appeal, what's the plan now? So we've now filed our notice. We have, I guess, what it is, 30 days or something. We are already beginning our appeal process, guys, and we're gathering the amicus briefs, if you will. But Dave, you feel confident? Yes. I mean, I know we've talked a lot, and we can't. I don't know what you want to share, but I defer to you. I feel confident based on our conversations. But you feel there's a lot of points here to bring up.
Yeah, let me say this. Usually when courts feel confident in their decisions and their rulings, they don't do these, if I was wrong about this, then there's this, and if I'm wrong about this, then there's this. They call that a belt and suspenders ruling. I think that a lot of times to the appellate panels, that stands out as well. If you felt strong about it, usually the court's going to say, I need not further address these other issues that were raised. And especially, you're not going to see sua sponte arguments made by the judge and not by any party. So I think that's going to stand out to the 11th Circuit. I feel like we have a really strong argument on the First Amendment. And look, appellate courts, they're like anybody else. They're going to look at what's the most important issues that are facing us. And when it comes to the Constitution, you can't get much more important than that. So I think they're going to take this case seriously. Absolutely.
That's really the import of what we're doing here, because again, the fundamental rights to which we've been provided by virtue of our founding fathers, they never get extinguished spontaneously, right? It's just they're eroded over time. And one of the concerns that I've spoken about, again, to a number of lawyers from a number of different states and from a number of different freedom of the press foundations, and all of them concur. This is a fight that has to be had out here on the periphery to make sure that it doesn't come into our backyards. It's really a matter of fundamental rights here, guys.
Well, speaking of my rights, something that really frustrated me is my last point as we wrap up. Like, the judge revealed a lot of information about my in-camera, supposed to be confidential, privileged conversations, and the way she wrote it with the amount of length it is, it reads nefarious. And I know you have read you're the only other people who have read my logs, specifically Dave. It's kind of frustrating how she's now put that out there. It almost feels like it's a play for Lively. Is that normal? I mean, she even says in-camera review reveals that responsive materials are directly relevant to the claim, which is absolute BS.
I don't know that she
I just don't
meant
think
it
she
to come off
understands
like
it,
that,
but sorry,
though.
go ahead. Yes.
Yeah, I don't know that she meant it to come off like that, Andy. I actually don't think she did. I think that, like you said a few minutes ago, she started right off in this case saying that she's not really that familiar with this type of issue. And so I think that has plagued the decisions throughout this matter, that she's looking at this through the lens of typical civil litigation where you're dealing with, privilege claimed as to, materials that experts prepare. That's not what's going on here. And privilege logs with regards to the reporter's privilege are much, much different than other privilege logs that attorneys typically prepare. And for that reason, like Jack said, you have to be very careful not to disclose too much, because if you put too much in the privilege log about what you're claiming privilege to, you've waived it at that point. And so we've been very careful about avoiding waiver. So it sort of stings that the judge actually found waiver in the fact that we were doing what the law says we're required to do. But again, we never got to make these arguments at any of the hearings. So, I think the appellate court's going to look at this and take that seriously.
Right. There
Well,
was
she was
another.
so key. Just one point to echo that. Sorry, Jack, and then I want you to do it. But like we took 3 months to provide it after nonsense. This is why I didn't want to provide it right away either, because she totally used it and revealed what was supposed to be privileged, confidential correspondence. That was clearly what it was. And she's already using it against me.
And we did it within the parameters, the time parameters the court allowed us to provide it in as well.
Correct.
So,
there was no errors in the court, and there was no issues in the court hearings saying that we had any problems. She gave us a delay happily, and then we met that immediately. Anyway, it's beyond frustrating. But Jack, go ahead. Final thoughts.
It's head scratching.
Just final thoughts again. At the end of the day, if a decision needs to be made upon the merits, substantive merits, and it's always much more important. It's important both on a state level and on a federal level. You'll find this is throughout jurisdictions in the United States, through all types of levels of law. Matters should be resolved on substantive merits, not on procedural technicalities. Right. And we never got to the substantive merits in this case, guys, because we never had an evidentiary hearing. Blake never testified, nor did she provide any affidavits or any documentation or any information. So rather, this was a function of a determination being made. Again, from our perspective, we think that determination had been made earlier on. There was an outcome that the court felt was the proper outcome, and then the court had to work very hard to find some type of authority to support the outcome, to support that decision. And again, based upon the manner in which the order has been drafted, there's really not any legal substance to support it.
And that's why we will be appealing. And I'm so grateful to these two. So please stop any weird, mean, ignorant comments. My lawyers have been bringing it. They've been working their butt off. Dave, shout out to you, especially. I know we've been on the phone a lot, putting some of these final pieces. And Jack, bravo. I stand by and support, and I don't feel like we're doing anything wrong at all. And everybody trying to claim otherwise, just do more research first is where the take is. And where you can help is as we're appealing. If you guys know of any other journalistic entities or big outreach platforms or networks that will help us spread this story, please reach out to me. You can email at press@popcornedplanet.com. You can also go to popcornedplanet.com to learn more about how to share our press release or get in touch or give to our Give and Go. I'll put those in the pinned comment. Jack, David, appreciate you guys so much. Guys, make sure you subscribe. Stay tuned. We got a lot more coming for you. And we got this battle. We are not giving up. Hit that bell for alerts. Smash that like button. Leave your comments down below. And stay tuned for more here on Popcorn Planet.